All right, so this is People v. Jerry Schmidt, file 24-6824FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
And good afternoon, Your Honor. For the record, Paul Talend on behalf of Mr. Schmidt, present tomorrow. Date and time set for sentencing this matter.
All right, and I have had a chance to review your sentencing memoranda that you submitted. Thank you very much.
Thank you, Your Honor.
Have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Any additions or corrections or modifications from the defense?
Your Honor, just the ones that I'm going to discuss that referenced my in my sentencing memorandum. We find it factually accurate. The information is, I believe, complete. There's nothing to note of deletions or errors and the like. I would just.
Did you have some scoring challenges?
I do, Your Honor. I have some allocution.
Okay, Ms. Goodrich, any additions or corrections to the factual information?
No, Your Honor.
I do think we need to change credit.
agree.
The credit was calculated through to July 22nd, and it's August 26th today for some continuances. So I haven't done the math.
35 days.
35,
And so it should be 477 plus 35.
512.
That's what I got, but I'm not saying it's right.
Okay. All right, so go ahead with the scoring challenge. You had PRV 7.
Your Honor, yes, in my first challenge comes in the discrepancy is the court would notice that when my client was pled to, I believe, 7 offenses on a habitual fourth, the scoring somehow came out at 5 to 23, and then 5 to 46. And then when he was scored on pleading to 2 offenses with no habitual, it came out to 34 to 67. That was the first start. I go back and I look at the PRV scores, and I look back to in the 10 years preceding the nature of this offense, there's a possession of marijuana from a different state. That offense translated to the state of Michigan does not equate to a criminal offense. It's the same way as in the Carolinas, they have, I believe it's called felonious speeding. But if you are convicted of that down there, it comes back to a civil infraction. So in the like, he has no cognizable offenses in the criminal law in the state of Michigan or elsewhere. Well, I should say to be acknowledged elsewhere. And it looks like the last conviction would be from 2007 for an indecent exposure in North Dakota. With that in mind, the 10-year gap, the 10-year rule applies in terms of the consideration for the previous offenses in the scoring. With that, my scoring is that all of the prior offenses do fall outside of the 10-year gap and therefore would not be calculated certainly to the higher level. The other side has it is that the PRV score of 10 for concurrent felony convictions, I believe, accounts for the.
Well, hang on. I'd like to do these one at a time. So you've said that you believe all of the prior convictions are barred by the 10-year gap rule.
That's my position, because if the court looks at it, there's nothing that if we go back, we're talking 2023, so we go back to 2013.
But he's got the 2016 and 2018 possessions of marijuana.
Those aren't criminal offenses in Michigan. If those, and I would equate this to the court, is that if those were Michigan convictions, they would have been automatically expunged by the state because they are no longer convictions to be entered on someone's record. Well, again, they would be convictions from other state. We're considering the way that they translate into the view of the Michigan Department of Corrections.
So, but the recreational marijuana was not legal in 2016, is that correct?
That is correct, but what I'm saying to the court is that had these cases been Michigan convictions rather than North Dakota convictions, the operation of Michigan law vacates them because it is no longer an offense inside the state of Michigan. The state of Michigan has no power to vacate an offense that is still a criminal conviction in another state. However, when it translates here for our consideration into criminal purposes, it's not a criminal offense under our jurisprudence.
Well, but for scoring purposes, the prior record variables, the statute counsels that convictions that are set aside or expunged are still counted as prior record variable convictions. So based upon the fact that in 2016, possession of marijuana was still a crime in Michigan, and even if it had been a Michigan crime and expunged, that would still score. I would overrule the 10-year gap objection and still leave the prior convictions fully scorable. Okay, so that takes care of your 10-year gap objection, and you had a PRV 7 objection. Go ahead with that.
As the PRV, I think other than the court only allows for me to score 10. I mean, in terms of my scoring, I would have all the others set aside and then only have this exist at a level of 10. However, if the court's going to overrule the 10-year gap, then I would make my position that it is properly scored at 0.
Well, I think that the PRV 7 is for concurrent or subsequent convictions. So I understood that to be scored at 20 points because in this case, on scoring the possession of methamphetamine, the sentencing offense, there are 2 other contemporaneous or concurrent or subsequent convictions, the R&O in this case, and the case down in Macomb County. So based on that, Ms. Gooder, is that your understanding on PRV 7? Based on that, I would think the PRV 7 is properly scored at 20 points.
The concurrent convictions are, I'm sorry, I believe those would fall out because those are subsequent beyond the court, and I believe those may have been addressed in the contempt here.
PRV 7 is for concurrent or subsequent convictions. So I'm scoring. So what's your next objection?
Okay, then it would be properly scored.
I don't want to hear the objection I just overruled. I want to hear your next objection.
So it would be OV12. Just if I may, Your Honor.
Sure.
Okay, so OV12.
OV12 was scored at 25 points for 3 or more contemporaneous felonious acts involving crimes against a person.
Okay.
However, the scoring offense, possession of methamphetamine, is not a crime against a person.
Correct.
So we couldn't score the 25 points. Is that your objection?
That's my position. I believe it should be properly scored at 10.
At 10. I think that is correct. Ms. Goodrich, you have any other position with regard to that?
I would agree, Your Honor.
Okay, because the scoring offense of possession of methamphetamine is not a crime against a person, it can't be part of a pattern of crimes against a person. So under OV12, 10 points could be scored because there are 3 or more contemporaneous felonious criminal acts involving other crimes. So OV12 will change from 25 points to 10 points. That would reduce the OVs from 40 points to, my goodness, now my math, 25. That
Yes,
means on the D grid, that would be, goes from OV level 4 to OV level 3, which is instead of 34 to 67, we're at 29 to 57. Is that right?
I would concur with that.
Sorry, so we're still on the D grid, Your
We're in the
Honor?
D grid for possession methamphetamine. We're in the F column for OVs or for PRVs. And we're on OVs at 25 points. I've got at 3 rather than 4. Changing the guidelines from they scored at 34 to 67 to now at 29 to 57.
That looks correct. I also want to challenge OV 19, Your Honor.
Okay, go ahead.
There was no threat to security of the penal institution in this matter. There's no convictions on that matter. The other one, as pertains to what was charged, under the statute, Mr. Schmidt was not technically a prisoner during the intake. So he was not a prisoner possession contraband because of the intake process. The intake process was not complete. So he was still a custodial arrest, which is a very common position to say, okay, I pick you up, I arrest you during the search of your person for admittance and for the corporal admittance into the DOC or into the jail. At that point, and even as a function of a sentence and a designation, that's what makes someone a prisoner ultimately eligible for a charge to possess something while in another place. However, in a situation such as this case, Your Honor, the possession of methamphetamine was, let's call it, already complete. And so the fact that the discovery of the possession or a subsequent possession or another amount occurred in another location does not change Mr. Schmidt's category from detainee or in custody under investigation to the status of prisoner. And so with that, there's no threat to it because he was not interfering with anything having to do with and it's scored currently at 15, which indicates that there was either a used force or threat of another person, used force or the threat of force against another person or the property of another person to interfere with, attempt to interfere with, or that results with the administration of justice or the rendering of emergency services. So just having meth doesn't actually interfere with anything. It causes no waves in the smooth sailing of the administration of justice.
Okay, I think there's some recent cases from the Michigan Supreme Court that I think may bolster your position with regard to the mere possession of a substance during the booking process. But I wonder if you have a position about 15 points can also be scored for use of force or a threat of force against another person to attempt to interfere with the administration of justice, which the case law does say applies to responding officers. And he also has the conviction for the R&O, and that in the description of the offense does include some threats to the officer, as well as it was a physical R&O, but also, for example, he told the trooper that if he got touched, they would be fighting. Is that not properly scorable for 15 points for a threat of force?
It's not, because I believe it certainly is consumed by the other offense that he's been convicted of. It is, let's call it a part of the R&O. It is within the full function of the offense of R&O. Words don't mean much, right? I think that the fact of there were 4 or 5 officers, much larger, much outnumbered than Mr. Schmidt. I don't think that there were facts in play that made, let's just say, any statement coming from Mr. Schmidt a reasonable threat. I think that by the time the police officers figured out that Mr. Schmidt had called the cops on himself from his paranoia, that his behavior once immediately out of the vehicle was the bulk of the behavior. So there's nothing beyond that, so that the behavior that the court's referring to is actually consumed by the R&O as part of the R&O. And thereafter, there was no danger or threat or any facts that support that it was perceivable or anything meant to interfere with the administration of justice, rather than just what's part and parcel to corralling a new arrestee.
Okay, thank you. Ms. Goodrich, what's your position on OB 19?
Your Honor, I would disagree. The defendant is first walking from his car towards the officers, yelling at them. He then is turning back towards his vehicle. I think that the officer is certainly going to treat somebody different who says that if they get touched, they're going to be fighting, versus somebody not saying that. I think that it was a volatile situation at that point with the statements that the defendant was making and his behavior and decisions he was making towards the officers.
Okay, I'm going to assume, without deciding, that the scoring would not, the possession of the drugs during the booking process would not be the basis for the scoring. But I do think it is properly scored at 15 points for a use of force or threat of force against the law enforcement officers in an attempt to interfere with the administration of justice.
Your
And
Honor,
the fact that you're gonna again argue an objection you already made. That's not how I do business.
I'm sorry,
Mr.
Your Honor, I
Tiggio.
just, there's.
I'm
there's a-
making my ruling, so please let me make my ruling.
If I.
Please
make a
let me make my ruling so that my thought process is not interrupted.
Thank you.
I do not do business. I let both sides speak their piece, then I speak mine. It is properly scored at 15 points for the use of force or threat of force against another person, the law enforcement officers, in an attempt to interfere with the administration of justice. The fact that he was convicted separately of the R&O does not prevent the basis of those facts being used to score offense variables. That happens all the time. There's no double jeopardy for scoring offense variables based upon conduct that another conviction was based upon. So the objection to OB 19 is overruled.
Thank you.
The guidelines as I have it scored is 29 to 57.
If I may, I have an objection just for the record, Your Honor.
Sure.
Part of the paragraph that the court was referring to that has to do with touch me and we're fighting, for the sake of completeness, if the court goes down a line and a half, it also, the next thing said, or the follow-up is that Mr. Schmidt, quote, I need to shut my fucking mouth and listen.
You overestimate my interest in objections I've already ruled on. Do you have another objection?
I'm making a record, Your Honor. Thank you.
Okay. Ms. Goodrich, any objections from the people of this room?
No, Your Honor.
All right, now the guidelines are scored at 29 to 57 months. Any allocution you want to make, go ahead.
I do, Your Honor. Thank you. I can appreciate that drug offenses are unfortunately common. However, the tendency in our state and with our jurisprudence is to properly treat mental health issues as mental health issues. In a situation like this, the court has seen and has enough evidence in front of it to indicate that this is a mental health issue. It's reflective of the road that is affected by the people who seek out self-medication because they have other instances going on and they might not be able to either have the proper foundations, the proper medical treatment, or the proper care to address truly how they got into drugs. As we've seen from Mr. Schmidt's behavior from this offense, as I've said, this is simply the product of a previously diagnosed mental health issue and the use of drugs. That collision led to this behavior. This isn't a malicious and terrible act. This isn't a vicious act. This isn't an act where Mr. Schmidt is out seeking to cause harm. Now, it's appreciable that this type of behavior does cause harm. Accidents, other type of people having to deal with the erratic behavior of these types of situations. However, they are brief. They are not a continuing pattern of criminal behavior. It's not something with which the court has to be afraid of. It's more the court has to be concerned about the path for the individual. And as we've seen from Mr. Schmidt, he has 25 years of minor offenses, other than these two offenses that brought him to court and the two offenses that now he's currently on probation for and the one he faces sentence for. There was the efforts to get Mr. Schmidt into treatment because treatment was what was thought to be best for him. These treatment programs exist to provide alternatives to the straight punishment of jail and to provide for the rehabilitation process that is certainly the most important part of the criminal sentencing aspect. I can appreciate that the court doesn't penalize and doesn't punish people out of enjoyment, and it doesn't punish people out of lack of other opportunities and options that exist for defendants in these situations. The court does it because the court will use every tool in the toolbox, and I ask the court to use the smaller hammers up front. Mr. Schmidt has 512 days. My scoring guidelines had him at 0 to 17 months. 510 days is about 17 months. So in understanding that Mr. Schmidt has served the maximum of my assessment, and of course it differs from what the court has assessed, that amount of jail time has provided a a punitive measure, a corporal punishment measure. It has provided this court the jail end of the portion of the punishment that Mr. Schmidt had to face based on what he did and how he got here. Now that he's faced that part of it, and now that he's done, let's call it the hard part, I'd ask the court to allow him to do the hardest part, where he has been invited to do so. Macomb County has put him on probation. They've provided for him to be through, to have programming once he's out of the Sheboygan County system. I ask the court to put him down there because I believe that aside from the, let's say, the unfortunate ineligibility of having two cases that may have kept him out of the treatment court in both counties, I don't believe that the, let's say, the policy that kept him out has anything to do with the fact that Mr. Schmidt is still willing and able to engage in the type of treatment that would keep him from repeating this. And I believe that there are the program in Macomb County, while not the truly four-corner, very hard, difficult treatment court, their treatment plans are very similar. He would go through the same thing. I believe that the stability that is provided through the home life and through the opportunities that exist from Mr. Schmidt to return back to his employment and to the rigors of that probation will provide him the opportunity. And I think this court can take comfort in the fact that while there may be concern for the general safety, certainly within the community and certainly within the state, that Mr. Schmidt has been punished sufficiently. We're going to allow him, we'd ask the court to allow him to make his way out of the hole that he's dug. And that those places, let's call it the ladder, that rope that he can certainly climb out with, or certainly turn around and hang himself with, exists back home. And what I asked the court to do is allow him to try to succeed there, because the court knows that if that success is not where it should be, the Macomb County they'll put him in DOC. There'll be no second chances. And if the court would like to retain Mr. Schmidt on probation for those purposes, accounting for the fact that he is currently indigent and, let's say, wouldn't be able to come here to the court, but the transfer to Macomb County would certainly satisfy both sides. It would certainly be a further carrot and a stick to allow Mr. Schmidt to prove himself and to recover himself for the rest, because again, then you would have two judges that could hold different sentences above him for similar or different violations. And if there's nothing more motivating than fear, the belief in self to succeed, which Mr. Schmidt has, and the self-confidence that it takes to acknowledge your triggers and to step beyond them and to stay away, as we've seen that he's been able to do in large periods of time over the last 25 years. And so I'd ask the court that we acknowledge that we've gotten our pound of flesh and that we let Mr. Schmidt prove himself to get through the mental health hurdles that brought him here. Because we know that if Mr. Schmidt can't adhere to the strict guidelines of what it takes to have clean mental health on the outside, well, then we know that he can go and have his mental health episodes locked up somewhere else. But I believe that we should give him that chance.
Thank you, Mr. Kelland. Mr. Schmidt, it's not required you would make a statement today, but you are certainly allowed to. Is there anything you want to tell me, sir, or no?
No, sir, not at this time.
Mr. Rich, any recommendations from people?
Yeah, sure. Thank you. The defendant is 52 years old. He has 7 prior felonies and 5 misdemeanors. His first crime was back in 1988 and pretty continuous since then. He served 4 years in prison, it looks like in 1993. He had a case in 2007, which he currently is not in compliance with. He stopped reporting in September of 2023, according to the PSI. And then in 2009, he spent 5 years in prison and now here before us today with a recent case in another county as well. I would ask the court to follow the recommendations.
Thank you. Well, Mr. Schmidt, no, we have to come up with a sentence that's proportionate to the circumstances of the offense and the offender. So the punishment has got to fit the crime, but it also has to fit the criminal. So as I would expect, given this circumstance, the your attorney has focused on the circumstances of the crime, which, although serious and dangerous, does have certainly some real mitigating factors to it, and would not be the kind of thing that would get a circuit judge all wound up about. And the prosecutor, by contrast, is going to emphasize your criminal history, which kind of does. So, you know, you've got a prior record that I do find troubling. You've got a little bit of everything. You've got some thefts, some assaults, including aggravated assaults, a sexual crime, a weapons crime. And then in North Dakota, I don't know what their laws are like or what this was, but something called a felonious restraint and something called a terrorizing. I don't know if that's just fancy words for some domestic assault. I don't know. But so you've got several prior felonies. You've been to prison before. You fail to appear in this case. And then while you're on absconder status and warrant status for several months, you commit a new felony down in Macomb County. That's all very troubling. And the prosecutor is, you know, I guess opted not to charge you with absconding in this case. That's fine. You know, but that happened. And so all of that would mean that, you know, if I just look at that, so if I look at just the crime alone, I would probably go toward lower end of the guidelines, whatever they are. If I look at your history, I'd go toward upper end of the guidelines. You know, so balancing that out, I think that a sentence within those guidelines is proportionate. I'm not going to follow your attorney's recommendation to essentially downwardly depart from what those guidelines are. So I think taking all those things into account, on the, I'm going to assess crime victims assessment of $130, their state cost of $136, and court costs of $350. On the R&O, I'll order you serve 512 days jail with credit for 512 days credit. And on the principal charge, the possession methamphetamine with the guidelines of 29 to 57 months, I'm going to commit you to the Michigan Department of Corrections for not less than 36 months to not more than 10 years with credit for 512 days previously served. And that's within the advisory guidelines. I think it is proportionate to the circumstances of the offense and the offender, and reduced the my sentence from what was recommended by the DOC, partly because of the reduction in the guidelines score as well. And so that's the sentence of the court. If you want to appeal from that, you can file an application. If you want a lawyer appointed for you and qualify, you have to make that request within 6 months. We're going to hand you a piece of paper explaining those appeal rights to you, Mr. Schmidt, and ask you to initial one copy for us, and the other one is for you to fill out if you wish to take an appeal. Oh, also the R&O is discretionary consecutive. I'll run that concurrent, so you get the credit on both. All right, so anything further from people?
No, Your Honor,
From
thank
the
you.
fence?
Oh, yeah, thank you.
Okay, thank you, Mr. Thailand.
Thank you.